Welcome to the board workshop on December 13th, 2016. I call this meeting to order. I declare that a quorum is present and the media has been notified. Are there any motions? Is there a motion to approve the agenda?
Madam Chair, I move that we approve the agenda as presented.
Is there a second?
Second.
All those in favor of approving the agenda say aye.
Aye.
All opposed, nay. The agenda is approved. We'll now move on and invite Mr. Josh Whitley to the podium to cover the roles and responsibilities of a board member and also the Freedom of Information Act.
Thank you, Madam Chairwoman, members of the board. Congratulations on your election. Thank you for the interim title of council. I appreciate the opportunity to be here tonight. I give CLEs around the state on the Freedom of Information Act. That just means I think I know what I'm talking about, but every time the issue comes up, it's really statutory based and you go back and you review it. So if you have any questions, this is to kind of introduce the concept to you, but you're going to have questions going forward, and I encourage you. I think I know what the answer is, but give me a call or call through the superintendent or through Sally. But tonight, Sally has asked me to kind of give a brief, some hot issues that you need to know about today instead of waiting till your February board training that the School Board Association will conduct, I believe probably in Columbia. That's statutory by law. The law says every board member shall be trained within 1 year of their election in a workshop. So that's your official training. This is to, let's do some nuts and bolts talking tonight. Interrupt me with questions, but just so you know, these are the topics I'm going to go through in order in case you're questioned about executive session. No, I'm going to get to executive session. But we're going to cover board members' powers and roles, public documents, FOIAs and exemptions, open meetings, executive session, agenda issues, miscellaneous issues. Madam Chairwoman, I think this is a great session to have. I know Ms. Blackburn called me a week or so ago about replying all to text, and I told her please have them stop because of the Freedom of Information Act. So this is a good, y'all got to govern from day one. Unlike county council, the school board gets sworn in 7 days. In county council, you get elected in November, but you don't get sworn in until the next year. Y'all got to govern from day one. So thank you, Madam Chairwoman, for doing this tonight. Public documents, open meetings, executive session, agenda issues, and miscellaneous issues. The Board of Education in your role. Your position and your power is derived from statute. Section 59, 1910, y'all are the management and control of the school district. Now, how that plays out and what your true role is a learning curve. It's a policy issue. Y'all are going to set your role. There is a current policy on your role. But at the end of the day, the buck stops with you. When the superintendent, who administratively and as the chief executive officer, the buck stops with her for a lot of things, but she's going to come to the board. You're going to know about the most significant problems. You're going to know about what's going in and out of the district because you have ultimate control and management, but she's going to run the day-to-day, and she's going to probably not tell you everything because you wouldn't want to know that. But when there's significant problems, Ronald Reagan said the buck stops here. Y'all are the buck. And this is where it stops on your desk, and it's derived from statute. All right, so what the state law says is your body is a complex local government entity that has the power to tax and spend. That's important. Y'all can leverage millage on folks' homes and property and cars and boats and so forth. Y'all have the power to tax. Please know that not every school board in the state has that power. It's different by district. There's a lot of things that are different by district. We're a Board of Education that governs the entire county. Spartanburg has 7 school boards. So by comparison, that's a major difference. We also have the power to say your tax bill is going to be X. Dorchester District 2, Dorchester District 4, our neighboring districts, they don't have that power. They have to submit their budget to county council. So there are things in the law that are different, but to y'all have a significant power to tax and to spend. You can tax real and personal property under the law. As a board, you can sue and be sued. You can bring an action In law, you got to be a person or an entity to bring a lawsuit. As a board, you can bring a lawsuit if you need to. You can also be sued as a board, individually or in official capacity. So you are an entity under state law. You can enter contracts. Importantly, you're not permitted under the law to enter a contract for more money than you got. And that makes sense, right? But it is statutory that you have to be aware that any contract for amount above revenues you have or anticipate or receive, that contract is void as a matter of law. And so that's important, but you do have the power to enter contracts. You have the power to hold real and personal property. It means this school district owns this building, owns Berkeley Elementary, it owns Cane Bay, and on and on. Y'all have the power to, and it stops at the Board of Education, to own real and personal property. Interesting, the last one I threw in there, that's a 2012 edition of the South Carolina Code of Laws. Y'all have the power to create a school and exempt it from regulation that applies to other public schools and so forth. I haven't, and maybe Ms. Blackburn knows, I haven't seen that exercised anywhere in the state yet. That's probably one of these school choice initiatives, but it does give this Board of Education the power to exempt a school from regulations. And you have to go through a process, you have to justify it, you have to fill out a plan and so forth. You just can't say Berkeley Elementary has no rules and everybody else does. But y'all do have significant powers over education in Berkeley County. Also, you are to provide schoolhouses, employ and discharge teachers. This is all from statute. I'm not just making up a laundry list of things I think y'all should be doing. This is what state law says the Board of Education should do. Control school property. The statute says you should visit schools in your district once a year to make sure it's in compliance with what the rules are for schools. Y'all should be in your schools. I know in years past, and I don't know if Ms. Blackburn does this or not, I can remember growing up, the school board would make school visits, maybe just in your district, formally scheduled or not. You certainly have the power to visit schools. You have the power to do it anytime you want from the statute. We'll cover it more at the end. Drop Ms. Blackburn an email or a call. Hey, I want to go for a tour of Goose Creek. I'm going to go by there in the morning. Let her know y'all are doing that. But it is in your powers, and that's a courtesy, of course. Laura or Ms. Kelly, I wouldn't let Ms. Blackburn know every time you're going to Marrington Middle because you'd be calling her twice a day. There's a mama hat and there's a school board member hat. So when you're there with your children and all that, we all know you've got kids at Marrington Middle and Howe Hall and Goose Creek High. Shannon's got kids in 2 of our schools. Miss Lee has kids in 2 of our schools. So that's not the type of thing that you need to let the superintendent know. But, I also represent Boulder Bluff Elementary. You don't have a kid there. I want to go by there. I want to see it. I want to walk the halls. Certainly do that. And just let Ms. Blackburn know, and y'all can figure that out. Y'all have the statutory duty to control the educational interest of the district. That's what gives y'all a lot of power to do a lot of things. If it's in the educational interest of the district, it's supported. Transfer and assign pupils, think you're going to be doing a lot of attendance appeals, and you're going to be doing a lot of decisions on that. That comes out of statute. That's what's vested in this board. You have the power to provide before or after school child care program. You have the you set the annual calendar. I'm sure the instructional department introduces a calendar for the year or for the next 2 years, however y'all do it. But by law, y'all have to set it, and that's why they bring it to you. So you kind of get the point that the powers of running this district come from statute, and they are invested in this board. The question then is how y'all delegate it back out through the superintendent and the various departments and the running of the district. You have rulemaking power, and I just threw this in there because it was in the statute. You have the power to insure motor vehicles in the district. I mean, where did that one come from? But that's in statute. This was my favorite one. Y'all have a huge perk. Section 5919.320 lets y'all cross bridges and use ferries for free. Wow. That is in state law that only Board of Trustees of Education districts can cross our bridges and use our ferries for free. So if you ever find yourself on a ferry, I better receive a phone call that y'all use this state law not to pay the fee. That's my one homework assignment.
One perk.
Board policies. Those two large three-ring binders are your policies. I'm going to defer to Ms. Blackburn and to Chairman Wofford on they have some ideas regarding policies. But right now, if you have a question, I kind of encourage you to start in the table of contents and see if you can find the topic and see if you can read the policy on what governs. But all these policies at one point or another were adopted by this body or your predecessor. And that's how this district is run. It's not, Ms. Blackburn or attorneys can't call the board every time, hey, we got this transportation issue, how do you want to handle it? We've got to go by policies and state law. And so this is really where you govern, is by setting the policy and asking the administration to follow policy, follow the rules, and carry out what y'all deem is appropriate. So I encourage you to read the policies, make highlights, make questions. Ms. Blackburn didn't create these policies. She has no pride of authorship that she's going to be offended if this body wants to change some policies or do different things. That's your power, and you have lots of work ahead of you if you want to go that way. One of the policies that rules these meetings is that Robert's rules shall govern board meetings. I will tell you that's extremely important. Extremely, extremely, extremely important. I'm involved in litigation right now, and the question's going to turn on Robert's rules and whether the chairman acted within or without of the Robert's rules. So that's a policy that Robert's rules governs. It's a very, very powerful tool to learn those rules, and it's something that also helps very much on the efficiency of meetings. So know that that's a policy that rules these meetings. Under your policies, you have three officers: chair, vice chairman, and secretary. And I will tell you, chairman, it's spelled out what they can do. They preside at meetings, they represent us at functions, they consult with the superintendent in the planning of the agenda, and they confer with the superintendent on crucial matters in between board meetings. They can call special meetings. The chairman controls the agenda and is the official spokesman. So we, by policy, know what Chairman Wofford's powers are. And it's limited to those items. It's limited to the board policy on that issue. If it needs to expand, if it needs to retract, that would be something for y'all to address as a board. Number two, vice chairman has the easiest job of all, stands in if the chair's not there. And secretary records minutes and can have professional assistance by policy at the discretion of the board. And I think Ms. Riddle is a very important part of that. So that's all your policies employ the officers to do, which is interesting. They're not empowered to make decisions in the interim. They're not empowered to, they could be, y'all could delegate. They are empowered only by what's in your policy, which is setting the agenda and bringing it to this body. So I just want y'all to be aware of those three roles from your policies. I would encourage you, I've already covered this, read your policy, consider a policy committee, maybe a committee of the whole, but that is where you will affect great change in the running of this district, is through your board policies that have been developed, quite frankly, for decades, and added here and there and amended here and there. Sometimes the laws change, and I'll come to you and say you need to adjust your policy because there's been this case or there's been this statutory change. Other times you'll see something that you don't like and want to change how we do business. The way you do that, no board member has the power to direct any personnel. You can no more walk in and tell your child's principal to fire the assistant principal. No one board member has the power to run the district, but 5 of you do. And so you do it through this body at this podium, and that's how you run the district, through policy, through hiring the superintendent, evaluating the superintendent, and terminating the superintendent if need be. That's kind of the 20,000-foot view on a board member's role. They'll get into much deeper detail at the lesson, but remember, hire and fire the superintendent, evaluate him, and set policies. Any questions on that first item? This is where there's going to be lots of litigation going forward, but we're not going to have it in this district. We're going to, freedom of information is a heavily litigated area of the law. And here's the general rule. When in doubt, you disclose it. When in doubt, you post the meeting. When in doubt, you open the meeting. When in doubt, you release the document. Every case you'll read on FOIA, our Supreme Court and our courts almost universally say the public has a right to know. And I'm a big believer in that. I'm a big believer in FOIA. I've been on both sides of the equation. I've FOIA'd and I've been FOIA'd. And it's a hassle. It means y'all have got to take different steps as a board member, and I'll tell you about that. But at the end of the day, it is a key and crucial component to governing and for the public to have trust in this body that they can FOIA and have information of what was done. Let me tell you why doubts favors disclosing. The first part of the statute, if you were to have the Title 30 in front of you, that's the first paragraph you would read. The General Assembly finds that it is vital in a democratic society that public business be performed in an open and public manner. And if you go on, everything must be construed so as to make it possible for citizens to learn and report fully the activities of their public officials and have access to public documents or meetings. When that's your first paragraph of a title, I can tell you almost every case is going to go against us and for the person to disclose or to have the meeting in open or to have the document be given to the public. It's that important to a democratic society. The General Assembly said it in the first paragraph. So what does that mean? When you're typing a text to the superintendent, is that FOIAble? Answer's going to be yes. We're going to talk about exceptions and exemptions in that standpoint, but just know communications with the superintendent, with each other, those are public documents under the law that will be FOIAble. Now, I'm recommending Ms. Blackburn to stop replying all for a different reason. Under FOIA, it's a FOIAble document. Yeah, we turn over the text, emails, and so forth. But I recommended stopping the reply all because that's actually an illegal meeting. When you're all on a text and having discussion, and we'll get to a meeting maybe right now. We'll talk about a meeting in a minute. But FOIA request, here's what a public record is, everything. If it's in a tangible form, it's a public record, regardless of physical form. That's retained by this body. So think emails, think school bus camera videos, think text messages. Now, I'm in the same seat y'all are on county council. Sometimes I have to hit delete and edit my emails when something I don't agree with happens. And what I tell myself, and it seems to work, would I mind my email being on a billboard in Moncks Corner? Because it's a FOIAble document. So if I wouldn't be embarrassed by it being on a billboard, or somebody getting it under FOIA and trying to embarrass me on a billboard, then okay, I'll hit send. But otherwise, your emails and your text are FOIAble. Now, I don't, y'all have all been issued iPads or Chromebooks or something. Let me tell you what Josh, and we've had a big debate at the state level. This is Josh Whitley's rule. I'm so uptight on FOIA. I only have my county council email on my county council issued iPad. I don't have it on my other devices. There are some, and actually your other county attorney and I have been involved in litigation with other municipalities. There are some attorneys that take the standpoint, if you answer emails on your home computer, they can get that computer because you might have saved an attachment there and so forth and so on. That's not been litigated, but it's been attempted to be litigated. I've been in the courtroom arguing those motions. So what I do is I don't put my county email on anything else other than the devices issued to me. When somebody wants my FOIAble public documents, I hand them the iPad. So everything I should have. Another rule, according to Josh Whitley, and I'm not saying this is statutory, but if you really believe everything's going to be disclosed and doubt resolves in disclosure, guess what? Folks email me all the time on my work email. They'll Google me, about trash pickup, and they'll email me on my work email. They can't find my county email that's 100 characters long. So what I do is I have the practice that I reply to them and I BCC my county email so that there is a record of every email I've sent or received in the county email, and that can be produced. So I would encourage you to think that way, because let me tell you something, when this body gets sued and you say, oh, we've turned over everything, well, give me your Yahoo emails. Well, I never used Yahoo emails for the work. If they ask a question, they've got a copy of it from somewhere. They know they've emailed you, and all of a sudden we're in trouble. And you might have to get all of your emails inspected. As an attorney, that's unacceptable. My clients can't have their emails disclosed or searched by a third party. I've got attorney-client privilege, obligations, and so forth and so on. So I'm convinced that a judge would agree with if I signed an affidavit that I conducted my email on school district email or county council email, and to the extent someone else used my personal or work email, I had the standard practice of forwarding it or blind copying my government-issued email. I believe a judge would say, great FOIA recognition, he's turned over everything. So I encourage you to think about that, what it does to open up your private computer, your private emails, if you don't have some kind of system in your set. Other county council members go, I don't care, whatever. But as to me, that's the process I've put in place, knowing how stringent this law is. And it's a criminal violation to willfully violate FOIA. It's a criminal violation. I'm trying to scare you into taking it serious. I know each of you will. But public records about everything. They exempt income tax returns, medical records, hospital reports, scholastic records, adoption records, library registration, and use records. That's a First Amendment issue. The public doesn't have a right to know what people are reading. That's their private First Amendment right to read whatever they want. So that's what the statute says are not public records. So that's why we don't turn over scholastic records, for example, as a school district. But think everything y'all do is a FOIA document. It is a public record. Now, see, those items are defined as not public records. These items are public records, but they may be exempt if the information is of a personal nature where the public disclosure thereof would constitute an unreasonable invasion of personal privacy. That's not a personnel exemption to FOIA. Emails about personnel are still FOIAble. That's a personal, if it's highly invasive to a personal issue, would it be exempt from disclosure? And the test there was the email a public record about their private business? Was it a social security number, something like that? Or was it an email in their official capacity? So there's a law enforcement exemption. We don't want the bad guys to know what we're doing and turning over investigation reports prematurely. There's matters exempted from disclosure by state law or federal law, actually. Think HIPAA and the Federal Education Rights and Privacy Act. Documents incident to contractual negotiations and land purchases. That's important, but you need to know what the rule is. You can go in executive session, or it can be an exempt from FOIA based on contractual negotiations. We don't want to be handicapped by having to negotiate in public. We'd be paying maximum prices on everything if the other side knew what our parameters were. So that's important to do it back there. But the moment it's inked, it becomes a FOIAble document. And the only matters that can be discussed back there are limited to what you're negotiating and so forth. That's not exempt. You can't just say, we have a contract about something. The public has a right to know we're negotiating a land deal, we're doing this, we're doing that. So that's when contractual negotiations will come up. Y'all will do a lot of that. Y'all are building a lot of schools. There's a lot of contracts. That can all go on back there. That can all be exempt from FOIA until it's finalized. Then it becomes public. Compensations based, and I think I have a slide on it, but it's based on if you make more than $50,000, your name can be in the paper with the compensation. Below that, and depending on the position, it will be published as a position in a general range. Communications with me are exempt. Communications with Brandon Gaskins or whoever else is your counsel are exempt. It needs to be in good faith. There was somebody I knew in government who would email his supervisor that he was going to lunch and copy the county attorney. He just copied the county attorney every time because that made it exempt. Well, that's not what makes something attorney-client privilege or work product. So, y'all know the issue about employment. Well, you may not. You don't have to disclose employment applications and positions until you have a final 3 candidates. If y'all were hiring a new superintendent, y'all had 10 candidates, all that's exempt. The moment you have 3 candidates, you disclose. And that's the type of thing, as it comes up, it would be mechanically, we'd look at the statute. Complainants. That's the personal information one. That's the test. If it's personal nature and not subject, or does it rise from your job? Salaries, we talked about that. That's how it would be disclosed. If you make more than $50,000, your name would be foyable in the amount. We know attorney work product. Employment applications, that's the top 3. Now, here's where your text message becomes an open meeting. The law says y'all have got to do all your business. Every vote you take, every motion you take, everything you do has to be done up here. All your discussion has to be done up here, unless there's a reason to be an executive session. So a text message of a group text would be a meeting if you start replying all. Here's why. Meetings. What does open meetings mean? That's where you take a formal action or vote in public session. Meeting means when you convene a quorum of the constituent membership of the public body, whether corporal or by means of electronic equipment. So corporal means here in this room or by mass text. That's a meeting. If you're to discuss or act upon a matter over which you have responsibility. So the moment you start replying all, you're discussing. That's why it would be important to receive information. If you have any questions, do not act as a quorum. Call the superintendent or your chairman and have one-on-one conversations in order to get the more information, because you just can't act as a body. Your power is when you're together, and so when you're together, it needs to be in the open. That's what FOIA tells us. Quorum, unless otherwise defined by applicable law, means a simple majority of the constituent membership of a public body. So let's break these two down. Is that a quorum?
No.
So if those 4 got together to talk about issues or policies they wanted to revise, they could do it all day long. By the way, it works nicely. That's the only 4 pictures I could get off the internet.
We're going to take some more of those tonight.
And if I'd known there wasn't going to be a crowd, my next slide, which I deleted, had Ms. Condor and Mr. Ramsey on a parade float, and I was going to say, if anybody joins the parade, we got a quorum. So right now, we don't have a quorum. 4 can meet. But if a 5th is there, you cannot meet. Yesterday, I got invited to a meeting at the county on an issue. Can you come an hour and a half before county council? Sure. I walked in the room, knowing I just wrote this PowerPoint. I walked in the room and went, 1, 2, 3, 4, goodbye. And I walked out. And they said, no, Josh, we need you. I said, absolutely no way. Everybody hear loudly, I am not attending this public meeting, because it would have been a quorum. So we do that often. We count how many are there, because it's a criminal violation to violate FOIA. A person could, but you know what? If we get sued, okay, we'll handle it. If we have to pay attorney fees, it's not going to break the bank. It's not going to kill us. If we get ordered by a judge to fix how we're going to do it, so be it. We'll live to fight another day. But FOIA is about public trust. And once you break that, that's a little more difficult to deal with. So if you break the public trust and have these illegal meetings, have quorums, that's really, I think, my caution to you is you're breaking public trust, and that's a lot more expensive than attorney fees or having to produce a FOIA response. So We're going to talk executive session too. And by the way, Madam Chair, will you keep me on schedule? I'm close. A lot of it is self-policing. What's the chances somebody would have ratted us out to know 5 county council members were meeting on an economic development project? Very little, but I knew. And FOIA is about public trust. And so I want folks to know, to the best we can, we follow rules, and I walked out. So 9 times out of 10, you're not going to get caught. You're not going to get caught on the carpet. But 10 times out of 10, you know. And so in executive session, we were in executive session last night, for example, for over an hour. Twice I went, that's not appropriate. And everybody in the room knows what that means. Oh, okay. Because it's easy to start talking another issue. Nobody does it maliciously. But each of you have the responsibility to go, that's not appropriate. We're not back here for that purpose. And we'll talk about executive session. So for you as a whole, you're your own police. And I would encourage you to know it's about public trust. And so that's not a quorum. So here's the elements of a meeting. Do you have a quorum? Here we need 5, whether in person or electronically, to discuss or act over which you have jurisdiction. So let's go through some examples real quick. If the superintendent emails all of the board with an alert, hey, X school went into lockdown today due to a bomb threat, is that a meeting? No, correct. If someone replies all and says, well, what happened or how do we handle it, is that a meeting? Yes. See how fine that line is? So do not reply all, because a reply all would have a quorum, you would have discussion, and it would be over a matter for which you have jurisdiction. Something happened at a school. Any questions on that? All right. Social gatherings or chance meetings are permissible so long as all the elements are not met. All right. So let's say the superintendent has a Christmas party. 5 of you show up. Is that a meeting? Correct. Anybody think that's a meeting? It's not.
Why is it not a meeting?
Only if you start talking about.
Correct. Mr. Span, Reverend Span, let's go back to this elements. You got a quorum, so you meet that element, but you're not there to discuss or take action over any matter that's within your jurisdiction. Now, 5 of you go in the corner and say, we're having this problem with this principal and da-da-da-da, we got a problem.
So until we discuss
So
the
you
business of the district.
Correct. Now, Reverend Span, somebody comes up to you and says, hey, you need to really come visit J.K. Gordon for the Christmas program, one-on-one with you. That's no problem, because you don't have a quorum there gathered. It's one-on-one with the principal, inviting you to a thing over a matter. So your elements may fluctuate during the night, but if you're not there to gather and to act or discuss as that quorum, you're okay. That's really a fine line, but it kind of makes sense. There are, I will tell you, there are times when 5 of us county councilmen show up to different things. And we had to get an opinion one time to say it was a chance meeting or social gathering. I'll tell you what it was. 5 of the 8 used to go to the executive committee of a local party. Well, the 5 of us are there, but we don't meet element 2 or 3. We have a quorum, but it's not there to discuss or take action over something we have jurisdiction. So if you have any of those questions, call me, but I don't think a Christmas party violates it unless you huddle up in the corner and start discussing. All right, and then the third example was real. If you show up to a county party's executive committee, is that a meeting? No. Unless you gather in the back and start planning what you're going to do on a county council matter. Your conscience will police the issue. And the law prohibits, it says we're going to let social gatherings because that's just obvious that we should. But it says you cannot use that exception to circumvent the law. In other words, hey, let's go to Ms. Blackburn's Christmas party and then we're there, let's talk about X, Y, Z. You can't use it to circumvent the requirements of FOIA. But your conscience is going to police it. Your willingness and desire to have public trust is going to police it. All right, notice of meetings, this is going to be largely, I guess, on Ms. Riddle. I'm making that assumption, and the chair and the superintendent. But this is heavily statutory, and what you need to know is you got to announce the date, time, and place. Has to be on a bulletin board somewhere in the public body, and 24 hours notice. And we're going to talk about amending that within 24 hours because that's a new development in the law within the last 18 or so months. You must notify the news and persons requesting notice. That's when Ms. Wofford will say, has the news properly been noticed under the Freedom of Information Act? That's where that comes from. And someone who has responsibility for doing it will say, we've properly noticed it via the Freedom of Information Act. The only exception is the budget requires advertisement in a newspaper with 15 days notice. When you pass your fiscal ordinance or your fiscal budget, you've got to get 15 days notice, have public hearings. But every other meeting you'll meet during the year needs 24-hour notice. And there's an exception, but we'll get to it. All right. Y'all going to be spending a lot of time back there. And you can violate FOIA in lots of ways back there. So this is one of the ones that's near and dear to me, because if we buy into this concept, the public has a right to know what we're doing, unless there's a limited reason not to. It's going to be incumbent upon each of you to be your own police, because I'm telling you, as much as I believe in it, I'll turn to the county attorney and go, oh, did you follow up on such and such issue? And I'll go, oh, that's not why we're back here. This executive session is very important, and it can come back to bite you, because I'm going to tell you, if there's ever a lawsuit and one of your colleagues gets deposed, it's our expectation they're going to tell the truth, and if they're asked, would y'all do X, Y, and Z in executive session, they're going to tell the truth. Yes, sometimes we would talk about other matters. So it's very important from a public trust standpoint to not to follow executive session. So let's talk about it mechanics. This is more orientation. You can't go back in executive session unless a majority of members present vote to go in executive session. So that takes a motion, a second. You can discuss it. Madam Chairman, my question would be, why are we going executive? Or, is this truly? You can discuss it. That's very rare. But motion, second, discussion, a positive vote, then you're in executive session. And when you're back there, the only members back there, school board members are allowed, and anyone else, the school board, the statute says anyone the governing body wants back there. But whoever goes back there is bound by the obligations of FOIA, the confidentiality. If you talk about something, there's going to be some very, very serious things y'all find out in executive session about students, about employees, about legal matters. If you disclose what happens in executive session, there is an interpretation of FOIA that you can be guilty of a crime. That there's a criminal statute of a willful violation of FOIA is you're guilty of a misdemeanor under South Carolina law. So there's lots of reasons, liability and criminal, that anything that happens back there stays back there. We very recently, within the last 2 years, know of an instance of this past board where a student was discussed in executive session. A board member called a board member who had just resigned, and that board member called and said, hey, let me tell you what your school board member was saying about you in executive session. And that parent has it on recording, and we have it to this day, of a board member telling them what another board member was saying about the student and the mother. If I were your attorney at that time, the sheriff would have been involved. That's how important FOIA is, and the sheriff might still be involved because the statute hadn't run. But there is a voicemail, an evidence. Hey, this is what was talked about in executive session. That cannot happen. I don't foresee that happen with the 9 of you and Ms. Blackburn 10. I don't foresee that. But no, that's a real example. And think about it. Not only is that a violation of FOIA, now we've got somebody who's not even on the board leaving a voicemail about the privacy rights of a student, which is protected under federal law. That's a real, real problem. So If it happens back there, it stays back there until it properly acted upon out here. You cannot take a vote in FOIA. In executive session. You can't make a motion in executive session. There can be no action back there, only discussion. And then you come out here and take whatever action you need to take based, if any, based on an executive session. Any questions on that? Chairman Wofford, is that? And then when you come out here, I don't know how y'all do it. There's a couple ways to do it. We have the county attorney report us out of executive session, but you need to announce to the public. Madam Chair, you might do it. I just haven't been here after executive session in a long time. You need to let the public know no action was taken in executive session. That needs to be on the record to protect us, to protect you, and then take whatever action you need to take. What we say at the county is members of council went into executive session for the purposes announced in the motion. No actions were taken. That's on the record, part of the minutes. That satisfies us under FOIA. There's lots of ways to skin the cat, but that's how we do it. So why can you go into executive session? You can go in there to discuss, and this all comes from a statute. You can go in there to discuss employment matters or disciplinary matters. You can go in there to talk about contracts, negotiations, and the receipt of legal advice. Discussion of security matters. You can discuss crimes and offenses. There can be discussion of matters concerning economic development. There was a recent case, I think it came out of Aiken County. When you make a motion to go in executive session, people out here cannot be wondering why you're going back there. It needs to be properly described. We're going back there for the appointment of a principal of St. Stephen's Middle School, or for the appointment of a director within the Department of Instruction. The test the Supreme Court articulated was, because it used to be, and this body was guilty of it, and a lot of bodies were, they would put all 5 reasons to go in executive session on every agenda, and the public was out here wondering, okay, which one of those are they back there for? If you do that, the Supreme Court's you're going to pay attorney fees and you're going to lose. The test is, the public doesn't have to know what's confidential and why you're back there. Why the specifics. But they need to know they're back there discussing a contractual matter. They're back there discussing a legal matter. The public out here needs to know why you're back there. That's the only thing that's going to pass that recent Supreme Court test.
Josh,
Yes, sir.
as far as after executive session and it's gone through the process, it's disclosed to the public, does the public then have a right to FOIA what was discussed in executive session once you're past all that?
Yes, no. Most of the time, and I don't know what your practice is, you have the right to take notes. But what they're going to FOIA are only tangible items. Most folks don't take notes for that reason, because then there's nothing to FOIA, right?
Right.
Then, if they do FOIA your notes, then you would have to go through, does it meet an exemption of not producing a public document? And it could still. If it's about employment matters, it probably won't. Remember, there's not the same employment matter that's an exemption to go in executive session is not under the public documents. It has to be highly personal not to produce a document about it. So that's a thing that, quite frankly, I think that's an inconsistency in the law. It should be, I just think that's clumsy writing in the statute, but that's what it is. But they could FOIA your notes. Let's take, for example, I saw Dr. Spencer walk in, a contract about building Philip Simmons High School. While that contract's being negotiated, they can FOIA it, we don't turn it over. The day it's inked, we would turn over that document from executive session, if it's about the contractual matter, and there's a document. Does that make sense?
Yeah, it does. Thank you.
So if you take notes in executive session, the answer is it could have to be produced, and when in doubt, we produce, right? So that's the problem there. So when you go in executive session, you can't say we're going in executive session. You have to say we're going in executive session to discuss A, B, and C, or A and B. It has to be announced as a purpose. If you get back there and you start if you go back there tonight, I think y'all are going to make some appointments. going to executive session for the appointment of X. And you get back there and start talking about whether or not this administrator of the district office needs to go, or something like that. That's not under the purpose for which you went back there. And one of you would need to say, all right, guys, let's stay on task. It's going to be natural. You're going to gravitate to topics. At least that's my experience. And you just have to self-police you. Let's stay within the purpose we announced when we made our motion. So the motion has to state the purpose, has to give the public an idea of what you're back there discussing. They can't be guessing. And then you have to stay on topic when you get back there. If you're back there to discuss an employment matter, the law allows that employee to say, nope, I want it done in public. So that's one area. At least I don't think we see that a lot. But just know that could turn an employment matter from back there to a public hearing or discussion. Discussions and negotiations, we've talked about that a lot. And note, once the contract is entered into, it is a matter of public record. So now, the fourth bullet point, only matters relating to the potential claim or discussions about the adversarial, what you're negotiating. That's what you protect. Any other matter about the contractual relationship isn't protected. And I'm not sure folks follow that. I think they just say the whole thing's protected, but the statute's very clear on that. Only those matters which need to be protected in the contract are subject to non-disclosure and back in the back room. All right. So don't vote, don't make motions, don't do anything other than discuss the reason you're back there. The chairman, and I'll just warn you not to get on her bad side, and each of you will police what goes on back there. And realize, y'all going to violate it. It's going to be natural. Just call yourself on it real quick. And at the end of the day, if you do violate it, the world's not going to end. I'm telling you. We can fix a violation, but you will violate the public trust, and that's harder to gain back. So when you lose a FOIA lawsuit, this district has lost FOIA lawsuits all the way up to the Supreme Court. That's not good. That violates public trust. That makes the public think y'all have things to hide, and why are you doing it back there when even the court says you shouldn't be? That's a problem. So we don't want to violate the public trust. And I'll probably say that 10 more times before the end. You're your own police and conscience. Only persons invited by the board may be in executive session. You cannot poll members in executive session. And I'm going to tell you, you're going to want to poll members in executive session. It's going to be natural on, hey, when we go out there, what are we going to do on this? You can't poll members. You'll have an idea from discussions on where members are on an issue, and that's it. And you'll probably have a vote count in your head. That's okay. But you can't say, hey, if I make this motion, who's with me? That's prohibited under the statute. You're duty bound and even criminally bound not to disclose matters discussed in executive session. And we already talked about the voicemail regarding the student appeal, which we could one day play you the voicemail and it would haunt you. You would never violate. It was so outrageous and so violative of the student's rights. It was absolutely a willful criminal violation of FOIA that came out of that room right there 2.5 years, less than 2 years ago. So be very careful of what you tell a former board member or whoever else of what goes on back there. That's a real issue. What happens if you violate FOIA? Injunctive relief, equitable relief, and attorney fees. So injunctive relief, that's a court's going to tell you, stop doing what you're doing. You're violating FOIA. You just fix it and move forward. Equitable relief, we don't know. What does the court think is fair to fix the situation? And of course, attorney fees, which can be significant. I mean, attorney fees can be astronomical. My bigger point, you lose the public trust. Agendas. This has been changed, as y'all know from y'all's own policies, chairman sets with the superintendent. This has changed in the statute and in case law because of statute was kind of not worded well. The Supreme Court came out with one result, so the legislature fixed it. So this is all, I would say, last 18 months. We all know you got to post the agenda 24 hours in advance. Okay, well, the Supreme Court stripped that requirement because the statute was clumsy and said, no, you don't anymore because the statute doesn't even require you to have an agenda. So then the legislature, I think last session, came back and said, here's what the rule's going to be. You got to give 24-hour notice, and something's inevitably going to come up that you need to amend the agenda, right? The day of, the morning of. You can do that only if 2/3 of the body approve. So it's going to take 2/3 of y'all to say, not a majority, but 2/3, yes, this issue is important enough, let's go ahead and amend the agenda. If it is an item that's for final action, which is more important for y'all than county council, for example. County council does a lot of things in 3 readings. So if it's first or second reading, we can amend the agenda within 24 hours because it's not final action. Y'all don't do 3 readings on everything. Sometimes you're doing a final action in 1 vote. If it's for final action, you cannot do it. You can't amend it within 24 hours, even if you have 2/3 vote, unless you make a finding on the record of why you need to, and it's an exigent circumstance. A darn good reason to do it. So I will tell you, we've only done it since this has changed once, and we made a record, on the record. We find it's an exigent circumstance because X, Y, and Z. It could be a legal matter that they've given you an offer and you need to turn it around quickly. It could be a contractual offer. There can be reasons to do it, but you better develop a record that gets in your minutes and is on videotape of why you do it, because then the worst thing could be for that action to be challenged and to stripped away because you violated the 24-hour notice. So that's been a big change for all of us over the last 18 months. Last summer is that 2/3 requirement within 24 hours. Any questions there? If you're going to be absent, this is a very wise. Shannon, Ms. Lee made sure I put this in here. She's exactly right. Tonight, we're a close call. If you're going to be absent, let the superintendent or chairman know, because she's going to be making sure she's got 5 folks here. Because if 4 folks show up, which happens, everybody here and everybody here goes home, because nothing you do will have the force of law. You won't have the requisite number of people to do anything. So you might as well just go on home. And that's kind of embarrassing. That would be a pretty bad Post and Courier article. Berkeley County School Board doesn't meet last night. So call the chairman, let her know, get folks here. I think that's the end of my slides, but let me tell you this. There's some unsettled points we've had people call in on the phone to make a quorum and all that. We don't know how the courts are going to treat that. Do y'all's rules even allow that? Ours do.
We've never done a phone conference before that I know of.
We've discussed it in the past, but it's never come to that before.
That's something y'all might want to discuss, whether the courts allow it in the future, who knows. Our rules, we allow it, but then we say the person can't vote unless the council says the person can vote by majority vote. I mean, it's very convoluted. Then we violate that all the time. So it's a dangerous path to go down, and the courts haven't said whether or not that's good enough. I think they would allow it, because if you remember, part of the statute said a meeting is, if you're in person, corporal, or by electronic means. So they recognize technology, and if somebody's there by Skype or something, I would make it very much the exception to the extent y'all look into doing that, because the public expects y'all sitting in those chairs doing the people's business. But no, that's kind of untested. That you'll hear probably a lot of workshops at the School Board Association on whether or not you can do that, and will the courts allow that, and so forth. I'm done unless any questions, or Madam Chairman, you have anything for me?
Do we have any
I do have a question.
Yes, ma'am, Ms. Lee.
When we go to the School Board Association meetings, we all plan, whoever plans to be there, if we have a quorum, does that violate?
Yes,
the
if you
law?
do one thing.
If we discuss school board issues? But if we're.
Berkeley County School Board
Okay,
issues.
so if we're discussing what we've learned in the classes, or, what we're discussing in the class, while we're in the classes, if we're sitting together, that doesn't violate?
I wouldn't sit as 5 in a class discussing how we take this lesson to our school district. Stay away from it. Discussing it in a group of other board members from other counties, fine. But don't gather and discuss, hey, I got this really great idea before dinner. I got this great idea we picked up in the session. Reserve it for here. Or have one-on-one conversations or 4 or less conversations. I mean, county councilman, we meet 4 people all the time. So you can have 4 meetings. You just can't have 5. But I would stay away from the 5 of you gathering and discussing.
Thank you.
Let me give you another, how y'all would handle this. We got notice, Secretary of Commerce and the governor invited council and other folks to go to tour the BMW plant. Is that a meeting?
Yes, if 5 of you go,
And 5 went.
because you're talking about county business.
5 went. So what did we do? Any ideas on how we handled that?
You should split up and ride in separate cars and go on separate tours.
I think that would certainly be a way to handle it. We went into executive session for the purpose of economic development, because it was an economic development trip. But we went into council chambers, called the meeting to order, went to executive session, and went and got on the bus. The other alternative would be to do what? Announce it to the public. Say, we're going to be going to do this. 5 of you go tour a school. Is that a meeting? Absolutely. Announce it to the public, or do it 4 or less. Fair enough? Any other questions? Thank you, Madam Chair.
I appreciate it very much.
Of course.
Just trying to get everyone's feet under them to get ready to go. So if there aren't any other questions for Mr. Whitley, is there a motion to adjourn?
So move.
Is there a second? All those in favor of adjourning, say aye.
Aye.
All opposed, nay. We're adjourned.